Hello there, my dear friends. I'm again back here and happy to rejoin you on the next modules that I will be tackling in. We will be covering now crimes against property, and we will be handling this in about 4 modules. And this is the first module, and just to show you the structure of what we're coming up with, we will cover 4 under crimes against property: robbery, theft, estafa, fraud, and carnapping. And we will have 4 separate YouTube uploads so that we are able to manage the length of the presentation. You will notice that there is a solid boundary here on the circle, which indicates that this slide will be covering robbery, while the theft, estafa, and carnapping are in broken lines, meaning there will be a second module for theft, a third module for estafa, and a fourth module for fraud. 4 different modules, independent but interrelated, and they will have this common frontline slide to guide you where you are. In the case of our first module tonight, which is robbery, this will be covering the general principles of robbery, and you'll notice here a gun that is pointed at a bank teller. We will this particular slide will cover, as I said, the general principles of robbery. We will cover the special complex crime of robbery with homicide, and then the second complex crime of robbery with rape, and finally we will discuss robbery in bond. So without much ado, and I already have this uploaded, except that since I'm using a very light Venetian blind behind me, when I was recording this during daytime, the sun reflection was giving me a dark impression, so you can barely see me. So I am making the second recording to make it clearer for you. So moving now to the first group in robbery, we talk about the general principles involved in robbery. Robbery is a crime committed by any person who takes a personal property belonging to another with intent to gain, by means of violence or intimidation against a person, or by means of using force upon anything. And this is in Article 293 of the Revised Penal Code, amplified in the cases of Ablasa versus People of September 2018 and People versus Concepcion in 2012. So robbery with violence against or intimidation of persons can be committed, simultaneously with the criminal offenses of homicide, rape, intentional mutilation, and arson. And if rape is committed with these particular crimes, there is now a criminal law principle that a second offense emanates, which becomes a special complex crime of robbery with homicide, or robbery with rape, or even robbery with arson. And the penalty would be ranging from reclusion perpetua to death under Article 294 of the Revised Penal Code. Moving on, the crime of robbery with violence or intimidation of persons can also be committed side by side with serious physical injuries, where the penalty will become reclusion temporal in the medium term to reclusion perpetua, or less serious physical injuries punishable by reclusion temporal, or with unnecessary violence or intimidation employed or physical injury upon any person not responsible. Meaning not responsible for the either the offense of robbery or actually the intended victim. And this is with the penalty of prisión mayor in the maximum or reclusion temporal in the medium term. Robbery with violence can also be committed in other cases of violence or intimidation where the penalty can range from prisión correccional in the maximum to prisión mayor in the medium term. The same citation of Ablasa versus People of September 2018 and People versus Concepcion of 2012 under Article 294, Section 1 of the Revised Penal Code. A while ago, we did mention that here, let's take a look. We did mention the issue of the personal taking. It says who takes a personal property belonging to another. And so it may be worthwhile to understand what is the taking of property. And that is what is in that particular slide. It says unlawful taking in robbery is the taking of items without the consent of the owner or by means of violence against or intimidation of persons or by using force upon things. This is very critical and I would like to emphasize this particular point. The taking is complete from the moment the offender gains possession of the thing, even if he did not have the opportunity to dispose of the same. I would just like to invite your imagination to a situation of a bank robbery. Hold up. When the bank robbers, let us say they are 4 bank robbers, manage to enter the bank premises and announce the hold up or the robbery, usually it's a hold up po ito. The immediate target obviously is to get as much of the cash that are readily visible and available. And so the tellers would be the ones subjected to the pointing of the gun and say, lagay mo lahat ng perang yan sa supot. And the robbers may have already brought their own bags, or they'll probably depend upon the bank. Chances are they would have their own bags. And so while the tellers are putting the bags, the crime of robbery has already started. And therefore, as soon as any money of the bank is handed to any of the robbers, then there is already physical possession and robbery has already been consummated. And while it is not complete, the fact of the matter is the offense of robbery has already started because of the possession of the robber of the money that was handed over. Intent to gain or animus lucrandi is an internal act that is presumed from the unlawful taking of the personal property belonging to another. So the moment the bank robbers receive the money from the teller, the first wave of receiving the money is already a presumption of unlawful taking. And there is therefore a visible possession which essentially now consummates the offense of robbery. Obviously, the additional funds that would be taken from the other tellers, and if they are able to coerce the branch manager to open the vault, then additional and bigger monies would be available for the taking. So even before the robbers, the hold-uppers, leave the bank premises, when they are already in physical possession of the money of the bank, then there is already consummated robbery. And so if at that point, the police officers would barge in and caught them right there, red-handed, then there is already a consummated criminal offense of robbery. They need not leave the premises in order for the robbery to be considered completed already. Let me now use this particular icon to go back to our table of or chart of contents. We're done with the general principles on the robbery, and the most important thing is for us to understand the robbery is consummated by the possession and control of the particular money or personal property or asset that was taken over. So we illustrated the example of a bank robbery incident. It is possible likewise that when there is a jeepney that is plying the route and there are hold-uppers there who suddenly brought out either their guns or their knives and started collecting the watches, the money from the passengers, and including the collection of the driver. Then for any thing that gets into their hands, that already would demonstrate possession and therefore consummation of the crime of robbery. Now, there is a more serious crime where the robbery is committed with another offense, which creates a consolidated offense called special complex crime of robbery with homicide. So let's take a look. In the case of robbery with homicide, you have a special complex crime of robbery with homicide. And the elements of the offense of robbery with homicide would be 4 elements. The first one is, as usual, the taking of personal property is committed with violence or intimidation against person. Second, the property taken belongs to another person. And third, the taking is animo lucrandi, a presumption that the taking is because of the intent to gain. And in robbery with homicide, by reason of the robbery or on the occasion of the robbery, homicide or death is committed or happens. And this is the case of People versus Layog, a September 2017 case, and an earlier People versus Ebet in 2010 to illustrate Article 294, Paragraph 1 of the Revised Penal Code. With the special complex crime of robbery with homicide, it is very interesting for us to consider certain fundamental concepts. Number one, in robbery with homicide, the original criminal design of the malefactor is to commit robbery. With homicide perpetrated on the occasion or by reason of the robbery. So in other words, the killing is in order to serve the perfection or the carrying out of the robbery, or the homicide itself, happened at the time the robbery was taking place. Robbery with homicide. The second is the intent to commit robbery must precede the taking of human life. In other words, it is not the intention to kill per se. The intention is to take possession and run away with the personal property of another person. However, after the intent, it is the intent that was already developed, then it is possible that the robbers may have resolved among themselves that in the event they need to take human life, then they will do it. But it is not the intention to kill. It is the intention to take possession of a personal property belonging to another. So in the case of the hold up of a bank, it is the intent is to get the money that is in the possession of the bank. However, if there is a need to kill, then the subsequent killing or the killing becomes a necessary component of having to rob the particular bank. Having said that, therefore, the homicide may take place before, during, or after the robbery. This is different. The first one is the intent to rob is already there, and the taking of human life may not even be an immediate concern. Meaning, some robbers would even kill. Ang hanap buhay natin, mang hold up, hindi pumatay. Yan. And the killing, which is the homicide, happens only when there is a need to arising from their intent to commit robbery. However, in the execution of the robbery, the killing, which is the homicide, may take place before, during, or after the robbery. Like before the entry to the bank, it is possible that the security guards have been forewarned, or they were able to properly assess that this is already in the process of barging to rob the bank, and so the security guards could have already fired the necessary defensive volley of shots. But the robbers were ready for that kind of eventuality. They either preceded the firing or they returned the fire, then in the process killed the security guard or even some of the bank employees or the depositors or any bystanders. In that particular regard, the robbery has not been consummated because they have not yet entered the bank. Neither have they been able to take possession of the money. And so the homicide itself, the killing of the guard, happened before. It can also happen while they're getting the money. And it can also happen on their way out. They were already in possession of the money. And then the security guard started shooting and the robbers also managed to kill some of them. It is only meaning the homicide is only the result obtained without reference or distinction as to the circumstances, causes, or modes or persons intervening in the commission of the crime that has been taken into consideration. So the only issue here is, was that a dead person when the robbery was being undertaken? Yeah. And if there is a dead person before, during, and after the process of possession of the money in the case of a bank robbery, or in the case of a hold up of a jeepney or whatever, the homicide, the killing happened, and it doesn't anymore matter according to this what is the reason why there was killing, what is the distinction of the killing, and so on and so forth. They become irrelevant. The issue is, may namatay during the time that the robbery was being executed by the robbers. The fourth matter says that there is no such thing as a felony of robbery with homicide through reckless imprudence or simple negligence. The constitutive elements of the crime, namely robbery and homicide, must be consummated. I remember in the basics of criminal law where we were taught about a crime can either be a crime of DOLO or a crime of CULPA, where DOLO is a criminal offense committed with intent. And in the case of CULPA, the crime came about because of negligence, lack of foresight, lack of skill, and negligence. Okay, and so with this particular thing, I remember my very good professor in criminal law, professor and former registrar of the University of the East, Attorney Rojas, who said and kept on emphasizing throughout the semester that in committing a crime cannot be a crime of dolo, cannot be committed by the act of culpa. There is no dolo from culpa. And if you try to really simplify the model, if a person is negligent, he can never have any intent at all to commit an offense. No? He was just negligent. He was just not doing the positive thing that will prevent a wrong act from happening that will damage or hurt another person. So it is his negligence, his failure to observe the necessary foresight and things like this. And so that therefore, he really did not intend to commit the offense. But the offense was committed because of his failure to exercise diligence. And so that therefore, that kind of crime resulting from culpa or negligence could not create a crime that was made out of an intent to commit that crime. Kasi nga yung culpa is purely absence of care, absence of diligence, no, negligent siya, criminal negligent, no. Kung negligent siya, meron siyang hindi ginawa. Kung meron siyang hindi ginawa, hindi siya pwedeng gumawa ng krimen na dapat may gawin, no, which is intent. Kasi may intent ka, ibig sabihin gagawin mo dahil yun ang intent mo. And so, again, remembering sentimentally Attorney Rojas, bless his soul if he is already dead. Siguro, baka namatay na rin dahil may edad na. He belongs to the generation of my parents. And so that therefore, he kept saying, a crime of culpa cannot create a crime of dolo. There is no crime of dolo arising from culpa. At napakalinaw naman yun, no? So in this particular case, when you talk about reckless imprudence, no, carelessness yan, no? At nakamatay. Hindi mo pwedeng sabihin, no, na yung robbery with homicide, no, is arising from an act of negligence or culpa. Why? Because the mother offense, robbery, is actually committed with intent. Yeah, intent to gain. Kaya nga, intent to gain. No, the taking of possession of a personal property with intent to gain. May intent yun. And so, hindi pwedeng yung intent na yun nanggaling sa negligence. Masyadong obvious na contradictory. So, there is no such thing. The conclusion is, there is no such thing as a crime of robbery, which is dolo, with homicide, which obviously becomes also now dolo and not culpa, arising from the commission of the homicide from a act of dolo, which is robbery. Continuing now. It is immaterial that the death would supervene by mere accident, or that the victim of homicide is either than the victim of robbery, or that the two or more persons are killed, or that aside from the homicide, rape, intentional mutilation, or usurpation of authority is committed by reason or on the occasion of the crime. We will pursue the next line because they are interconnected. Number 5 says, it is likewise immaterial that the victim of homicide is one of the robbers. Ang napatay kasama nila. Okay? The felony would still be robbery with homicide. Now, this is now a very beautiful concept. When the law now mentions robbery with homicide, the robbery obviously is the intended criminal act of possession of personal property of somebody. Now, the homicide is something that came about either because it was intended, no, to help the robbery, no, to execute the robbery, or it happened while the robbery was being undertaken. Now, here is the more beautiful one. The act of robbery and the act of homicide, while interrelated and interdependent with each other, had a characteristic where the robbery was intended, but the homicide was simply defining the situation that a person was killed at the time of the robbery or as a consequence of the robbery. Now, here, very important, the death, which is the homicide, no, could be as a result of an accident, no. What is the accident? For example, where they entered the bank, and it so happened that the robbers did not intend to kill, and so they brought toy pistols rather than real pistol. The only problem was when they entered the bank premises, one of the security guards, pulled his gun because he probably suspected that there must be something seriously terrible with this group of four robbers. No, napansin niya ibang kilos. Bumulot siya ng baril. Napagbulot siya ng baril, no, nakalabit niya yung baril, siya ang tinamaan ng baril at patay siya. No, aksidente. Now, will this now fall within the concept of robbery with homicide? Hindi naman yung mga hold-upper ang pumatay sa kanya. Na-aksidente siya, pagbunot niya, pumutok. The answer is yes. Because the offense of robbery with homicide, the simple complex crime, did not say, well, it was the first one is the homicide was intended, the killing was intended to facilitate the robbery. Pero there is another one which says that when the robbery was happening, no, the killing was also happening. So those are two different things. Yung isa, the homicide was necessary to effect, to carry out the robbery. But the other one is saying that when the robbery was taking place, homicide or killing took place. That is the reason why by mere accident, pwedeng yung security guard nabaril niya yung sarili niya mismo sa pagbunot niya. Or for example, yung mga robbers, wala silang balak na pumatay, kaya walang laman yung mga baril nila. Pero nagkataon, yung isa, hindi niya na-overlook niya na hindi pala natanggalat yung bala ng baril niya. Kaya nung bumunot yung security guard para paputukan siya, kumalabit siya. Hindi niya ine-expect pumutok. Come to think of it, mere accident lang yun eh. Kasi alam niya wala namang puputok dun eh. Pumutok. So by mere accident, natamaan yung gwardiya, patay pa rin. Why? Because there was no intent to kill. Pero, the killing happened at the time they were undertaking the robbery. So hindi dahilan yun na ginamit nila yung pagpatay para makapagnakaw sila. Hindi. Napatay yung security guard by accident lang na nangyayari yung kanilang robbery. Now, the second one is that the death, no, happened where the victim of the homicide, no, yung hold the pin, yung mga mga taga-bangko or yung mga depositor. The victim of the homicide is other than the victim of the robbery. How? For example, may nagdi-deliver pala doon, no, yung Grab, dineliver yung sandwich ng McDonald's or Jollibee. And the process, nakasalubong nila, nabunggo, no, nagkasagutan kaagad yung robber, no, napabunot ng baril yung robber, pinaputukan. Wala namang relasyon yung delivery boy ng Grab para deliver yung pagkain doon sa bangko eh. So here, the victim of the homicide, that particular delivery boy, is not the targeted victim of the robbery. And yet, because he was killed while the robbery was already ongoing, the crime that was committed is still robbery with homicide of a victim that has nothing to do with the robbery. Okay, on occasion yun of the robbery. Or two or more persons are killed, and this may or may not be related to the crime. And as I said, aside from the homicide, or that aside from the homicide, rape, intentional mutilation or usurpation of authority is committed by reason or on the occasion of the crime. It will still be robbery with homicide, no? Ngayon, kung nangyari na may na-rape, no, dilalagyan with rape. Yan. Or with intentional mutilation or with usurpation of authority. Hahaba lang yung kulatilya nung robbery with homicide. Now, this is very important. If in the process, may napatay na members among the band of robbers, may napatay. Does it matter na yung napatay na yun, no? Ang pumatay either yung police, security guard, o sila mismo nagkabarilan by mistake? The answer is it does not matter whether the person who is dead is one of the robbers. Basta may namatay. Ang krimen pa rin doon sa mga mahuhuli is robbery with homicide. Kahit na sila mismo ang nagpatayan. Homicide pa rin. Kasi ang katwiran, if you notice the logic of the banks, kung hindi kayo nag-robbery, wala sana lahat yung patayan na yan. Kaya ngayon may nagkapatayan, kahit na nga kasama nyo, kayo pa rin ang mahahabla ng robbery with homicide. And so this is in the matter of our favorite friends who would argue on situations like this. Magpipilosopuhan yan, no? Puro pagalingan ng logic. And therefore, with this lecture, we are now saying, wag nyo na munang pagdebatihan ang ibang logic kasi this is the logic that was given by our people when Congress enacted the law, the revised penal code. Hindi na natin kailangang ulitin yung rason kung bakit ganyan ang batas. Na kapag robbery with homicide, basta sinimulan yung pagnanakaw, pang-hold up, pag may namatay, ang kaso doon sa mga nang hold up, robbery with homicide. Hindi na dapat pagdebatihan. Why? Because yung reasoning na yon, pinagdebatihan na yon, na yung iba sa atin na magpipiloso puntasyo dahil hindi alam yung batas, walang silbi yan because that will not be binding before the law. Unless that person who wants to be piloso puntasyo now runs for Congress or the Senate and moves to amend the revised penal code. No? So among us who are studying the law, whether you are a student of law or a lawyer already, or you are a Filipino wanting to understand the law, which is your right, no? You no longer have to dig in another set of philosophical views. The philosophical view of our people who enacted the law is already provided by the law, amplified by the decision of the Supreme Court. Yan. Ha? Kaya yung mga kukuha ng bar exam dyan na pilosopo ng pilosopo ang pangangatwiran at hindi pinag-aralan yung batas, talagang hindi sila dapat gawing abogado because the only people who are authorized to become attorneys at law are those who know the law. And so when they go to law school, they are supposed to study the law. Ang problema, no, hindi naman nag-aaral. Papasok, hindi therefore naiintindihan yung pinag-uusapan. Pagkatapos makatsamba ng 75, 76, 78, pumasa, gumraduate, kumuha ng bar, kapos. Tapos babagsak, galit na galit. Tama naman na yung sagot niya. Din, tama naman sagot ko. Bakit ako bumagsak? O kaya pag tinanong ko, bakit ano ba ang sagot mo? Ayun, pakikinggan mo na. Alam mo yung tamang batas nandito.
Ang pinoproblema, hindi yun ang sinasabi niya. Nangatwiran siya ng sarili niyang pilosopuntasyo. Siyempre, mali. Kasi dapat, para maging abogado siya, alam niya yung batas. No? Dura lex sed lex. And so he does not have to rationalize the law on his own philosophical reasoning. Hindi kailangan ng kanyang pagiging pilosopuntasyo. Kaya siya attorney at law, alam niya yung batas kasi pinag-aralan niya. Hindi siya iimbento ng sarili niyang pilosopo. Next, once homicide is committed by or on the occasion of the robbery, ayan natin mo, may nagawang patayan. At yung patayan nangyari, noon nangyayari yun on occasion of the robbery, the felony committed is robbery with homicide. Okay. So walang relasyon kung sino yung namatay. Basta may namatay. Whether you intended victim ng robbery or sila na nanguhold up or bystander, hindi po, basta may namatay. No? So ang robbery with homicide, may nakawan, no? May hold upan at may namatay. Hindi importante kung ang namatay yung hinold up din o yung nang hold up o yung usyosero o yung bystander o yung pulis o sino pa. Basta may namatay, whoever committed the robbery will now face the criminal prosecution for robbery with homicide. Okay, siya may kasalanan kung bakit may namatay. Kasi sinimulan niya yung kalokohan ng hold-up robbery. Okay. Number 7, all the felonies committed by reason of or on the occasion of the robbery are integrated into one and indivisible felony of robbery with homicide. So kung may namatay, hindi lang robbery ang krimen. Magkakaroon ng hindi rin dalawang krimen. Hindi robbery and homicide. Kung hindi, magkakaroon ng isa as defined by the revised penal code na special complex crime of robbery with homicide na may sarili siyang parusa. Nga, reclusion perpetua to death. Ito na ngayon na maganda. And this has always bugged me when I was when I was a law student in first year. What happens now? Robbery with homicide. Pero yung homicide under crimes against persons, pag nagkaroon ng qualifying aggravating circumstance, yung homicide pumapanik na murder na mas mabigat ang parusa. Okay. Hindi ba mangyayari, hindi na robbery with homicide, maging robbery with murder na? Like, for example, yung pagkakapatay, lagay na natin, yung napatay talaga, yung victim din ng robbery. Binaril nila. And when he was shot, there was treachery because of the suddenness of the attack. He had no means of defending himself. Okay? He has no means. Okay. So, hindi lang homicide yun, kundi murder. Should it not be proper for us, therefore, to title the offense and call it a robbery with murder? Now, the law now explains to us, to the Supreme Court. The Supreme Court said that when the offense is robbery with homicide, the homicide does not only follow the strict definition of a person being dead. That particular word of homicide, sabi na nga dito hindi na pinag-uusapan kung ano yung kanina, ano yung circumstances of the death. Basta homicide yan. But, kasabihin, Mr. Supreme Court, yung pagkakapatay meron hong elements ng qualifying aggravating circumstance like treachery, evident premeditation pinag-isipan talagang papatayin din talaga as part of the homicide. Tsaka binayaran po sila na hindi lang sila magnanakaw, kundi papatayin pa yun. Okay. So, ang dapat ipanik na murder. Ang sabi ng Supreme Court, pag ginamit natin sa crime na robbery with homicide, yung homicide na yun, hindi natin nililimit sa simple definition of homicide. Pag tinawag na homicide in the offense of robbery with homicide, that homicide will represent a broader generic meaning to include murder, to include parricide, to include infanticide. And so when you file a case against the robbers, no, yung mga hold-upper, ng robbery with homicide, but when during the act of killing the victim, they adopted treachery, katraidoran. Okay. Then, while the title is robbery with homicide, pwede mo nang lagyan ngayon yung information, no, with the aggravating qualifying circumstance of treachery because blah, tak, ang detalye. Then that would already satisfy the requirement of defining exactly the coverage of the word homicide in robbery with homicide. So, hindi na pinapalitan ng robbery with murder, robbery with parricide. Hindi na. Pag sinabi mong homicide yon, pinalawak yon under the concept of robbery with homicide. Yan po ang logic ng batas natin as enunciated by the Supreme Court. Hindi na po tayo iimbento ng iba pang reasoning. Next, number 8. This fourth asportation you will encounter in the study of robbery. Yung asportation po, yung taking away. Kasi normally, pagka hinold up mo, siyempre aalis ka, tatakbo ka para itakbo mo yung ninakaw, no? Para maibenta mo, maidispatcha mo. And so, ang question is, paano kung hindi mo pa natatakbo yung robbery na yun? Katulad sinabi natin na, ilagay mo yung pera dito na, ilagay mo sa lalagyan, inabot na sa'yo, then hindi ka pa nakakaalis sa bangko. No, you have not taken away from the premises of the bank the loot. No, and so there was no asportation. However, when the taking away or asportation was already proven, it was already established beyond reasonable doubt, tinakbo na, the conviction of the accused is still justified in court, even if the property subject of the robbery is not present anymore in court. Kumbaga sa proven beyond reasonable doubt, may CCTV. Nando na yung mga bank officers and employees na sinabi na, ito ho ang ninakaw sa amin, 5 million. Yan po ang mga nagnakaw na mumukha namin. Ito ho tumutok sa akin at nahubad niya ng konti yung kanyang bonnet, nakita ko. Okay. Nakabonet ho yan, pero meron hong merong birthmark dito. Ayun ho, kita ho. Or may tattoo ho yan, dito sa ayun, mga identifying mark. So in that particular case, the defense can no longer set up na, hindi nyo naman pinakita yung ninakaw. Hindi, proven na yon by the additional evidences that were available. Number 9, the property stolen may have been abandoned. Wala ho sa amin hindi ko may nagnakaw. Bakit? Kasi pagtakbo nila, itinapon nila sa bukid, hindi na nila nabalikan. Hindi pa rin makita or nakita later. Or thrown away. And, for example, to remove the evidence, pare, mahuhuli tayo. Sunugin na natin itong perang ito. Di wala silang mapapatunayan sa atin. Di ba? Na wala sa atin yun tinatawag natin na corpus delicti kuno. Wala. In that particular case, may have been abandoned. Patutunayan. Sabihin andun nakita namin yung bag. Tinapon nila dun. Thrown away, abandoned. Or destroyed by the driver. Sinunog po pero may natira po ito. And then, yung mga nasunog-sunog, ni-reconstruct ng NBI, yun ang mga pera ninakaw. Or, ito na ngayon ang pinakamagandang tanong this is the most controversial among laymen na pag nagdidebate. Pare, blakit na ng blakit ng hold up Tinutukan mo ako ng baril, kinuha mo yung 10,000 ko. Sige, pagpalagay natin, kinuha ko yung 10,000 mo. Kagabi yun. Kaninang umaga nagsisi ako binalik ko sa'yo ano pa nawala sa'yo? Wala na nawala sa'yo. Na-recover mo at tinanggap mo na at pinirmahan mo pa. Di wala na akong kasalanan. Diba? No. It is very important to go back again to our first few slides when we said, no, the taking away has a requirement of possession. Pagka nahawakan na, nung nagnanakaw, yun ang hold up, yung kanyang property na kukunin, tapos na ang kaso ng robbery, na-commit na niya. The fact na sinoli niya, no, yung ano, the admission of guilt pa kayo na siyang kumuha. Kasi, ba't niya isosoli? Diba? So, hindi niya pwedeng sabihin na parang ang principle of impartial delicto na, kinuha ko sa'yo, may kasalanan ako. Pero sinoli ko naman sa'yo, tinanggap mo naman, di yung ninakaw ko, ninakaw mo din. O, dahil tinanggap mo yung nakaw ko, di wala na tayo manos. That thing doesn't work well in the law because the law says that even if the owner recovers the property either by the direct return of the by the robbers or nakuha nahabol ng owner, that did not erase the fact. Remember, sinabi natin, robbery is already consummated when the goods were taken over and the critical part is possession. Pag nahawakan na, at yung example natin, pag kinuha na nung teller yung pera, nilagay na roon sa lalagyan ng pera, inabot na doon sa right there mismo sa harap ng teller, consummated na yung act of rape dahil hawak-hawak na nung hold-upper yung kanyang property na kukunin kahit na hindi siya nakatakbo. Hindi niya pwedeng sabihin, dumating na ho ang pulis o di sinoli ko na ho yung pera, wala na ho kung kasalanan. Hindi pwede yun. Hindi. Nung dumating kami, hawak-hawak mo pa. Siyempre, huli ka na. O di sinoli mo or inabot mo sa amin. Okay, pero tapos na ang kaso mo. Admission of guilt mo na nga yun ba't mo isosoli kung sa'yo yun, di ba? Hindi sa'yo yun, inamin mo, kaya sinoli mo. Kaya, you are already guilty and you should be penalized for that in the case of consummated robbery. Okay. Continuing now on robbery with homicide. When homicide is committed by reason or on the occasion of robbery, all those who took part as principals in the robbery would also be held liable as principals of the single indivisible felony of robbery with homicide, although they did not actually take part in the killing unless it clearly appears that they endeavored to prevent the same. Kung mamimiloso po yung mga pilosopong taksyo, sasabihin apat po yung mga hold-upper na yan O, pinasok ho si Mang Kanor doon sa bahay niya kasi meron siyang 10 million na napanalunan sa loto, hold upin ho nila. Okay. Ngayon ho, nung pumasok sila, may baril din pala si Mang Kanor, nakipagputukan po. Natamaan po yung isa ron sa mga hold-upper, patay po. Sabi ho natin, pag may patay, kahit na hold-upper siya, yung tatlong naiwan, robbery with homicide pa rin ang kaso nila. Yes, pa rin ang kaso nila. Ngayon, sasabihin ng tatlo, ba't tatlo lang ho kami? Di yun ho din namatay, no? Dahil ho, kasama siya sa amin sa robbery with homicide, kahit na siya ho napatay. No? Mamimiloso po. Practically, yes, except that the person is already dead, is already absolved of criminal liability. But before that invocation of absolution by death, technically, co-accused pa rin yung bumulagta na yun. Robbery with homicide. Pero, isa lang yung pumutok. Let's say, napatay naman si Mang Kanor. Napatay. Pero isa lang yung pumutok kasi isa lang yung may dalang baril. Yung nagli-leader, siyang bumaril. Ibig mo sabihin, siya lang ang may robbery with homicide. Yung iba, robbery lang. Hindi. Under the robbery with homicide concept, all those involved in the robbery will be all charged under robbery with homicide. Pati yung pagpatay kasama. Unless, mapapatunayan nila na pinipigil niya, yung kung sino man yung pumipigil, inaawat niyang pumutok yung bumutok pero nakaputok pa rin. That will be very difficult to prove, but that is the principle. Patunayan mo na pinipigilan mo yung tao na bumaril. Therefore, malilibre ka sa homicide. Sabit ka pa lang to sa robbery. Continuing now, if a robber tries to prevent the commission of homicide after the commission of the robbery, he is guilty only of robbery and not of robbery with homicide. So ito, nakuha na nila yung pera. Kasi sa bangko, dala-dala na nila yung maraming supot. Oh, halika na, takbo na tayo. Hindi, itong tarantadong anong ito, security guard na ito, o itong manay niya na ito, lumalaban pa kanina, sumagot-sagot pa, paputok ka, wag na pare, wag na, tama na yan. Oh. Halika na, lumakad na tayo, hilahin na tayo. Hindi, pak. Well, if the person who fired the shots, no, together with the other members of the robbery gang, would all be held liable for robbery with homicide. Pero itong umaawat, na kung talagang umawat na, lalo na naputukan din siya sa pag-awat niya, then he is the one that will no longer be charged with homicide. He will only be a co-accused in the robbery case. Yung tatlo, robbery with homicide. All those who conspire to commit robbery, nagplano with homicide, are guilty as principals of such crime, although not all profited and gained from the robbery. One who joins a criminal conspiracy adopts the criminal design of his co-conspirators and can no longer repudiate the conspiracy once it has materialized. No? So said, all those who conspire to commit robbery with homicide, no, are guilty as principals. Pero ibig sabihin, present siya doon sa scene of the robbery, pang-hold that. Kasi kung wala naman siya doon, he has no participation in it. No? So that is essentially the explanation of robbery with homicide. Very interesting. Diyan medyo maraming magagandang aspect and we have discussed that. And therefore, we have learned the special rudiments of robbery with homicide. So, robbery, pang-hold up. Homicide, basta may namatay. Hindi na hulugan yun ng hold upin o kung sino man. Basta may namatay, robbery with homicide, ang kaso nung lahat ng mga nang hold up na yon. In the case of People versus Palema, July 2019 decision. In the case of People versus De Jesus, ito en banc pa ito in 2004. There is just one modification that will be picked up even later. But in the case of a robbery in band with an unlicensed firearm, which was given in the November 2022 bar examination, the issue is robbery with homicide is punishable by the indivisible penalties of reclusion perpetua to death. Dalawa ang penalty, no? Yung mas mababa, reclusion perpetua, 40 years. Pero kung merong death penalty, ang maximum death penalty. The penalty of death is death, no? When there is one aggravating circumstance. Pag nagkaroon ng one aggravating circumstance, kasi katulad yung sinasabi natin, homicide, pero merong treachery, ayun, aggravating circumstance. That will now elevate the penalty for robbery with homicide from reclusion perpetua to death penalty dahil merong aggravating circumstance. Yun ang importante na alam mong homicide lang tawag pero hindi lang pala siya homicide. Meron siyang qualifying aggravating circumstance. Pero merong isang instance na hindi siya qualifying aggravating under the revised penal code. And this is under the Republic Act 8294, no? Under PD 1866. 1866 muna, amended by Republic Act 8294 on the use of unlicensed firearm in robbery with homicide. Ang sinasabi dito, if the offense is robbery with homicide and there was the use of an unlicensed firearm, the fact of the use of an unlicensed firearm in the robbery with homicide will establish the special aggravating circumstance that the penalty for the robbery with homicide will now be elevated to death penalty from the original reclusion perpetua. Yan po ang magandang concept. So that ends our discussion on robbery with homicide na may pahabol pa, robbery in band with unlicensed firearm. Meron pa pong additional yan mamayang konti. And so we have done with 2 modules, general principles of robbery and robbery with homicide. We will now proceed with robbery with rape. Before we proceed here, it is possible that there was already an offense of robbery with homicide kasi may namatay. But in the process na merong namatay, ang ginawa din, meron ding rape. So there will be now robbery with homicide with rape. Yung rape ngayon, mangyayari noon, aggravating circumstance yun. Noong single indivisible penalty na robbery with homicide. Pero for example, robbery lang, walang namatay, pero merong ni-rape in the process. Let us take a look at what happens. In the special complex crime of robbery with rape, the elements of robbery with rape are the taking of personal property committed with violence or intimidation of persons, the property taken belongs to another person, and the taking is done with intent to gain or animus lucrandi. Pare-pareho yan in all the offenses of robbery. Pero pagdating ng robbery with rape, the robbery was accompanied by rape, and there is a series of decisions of the Supreme Court ranging from People versus Gabuya in June of 2016 and the latest is People versus Rumobio in October of 2017 to implement Article 294 in relation to Article 266A and B as amended by Section 9 of Republic Act 7659 of the Revised Penal Code. Here, the concept of robbery with rape gets into this picture. The original intent of the accused was to take, with intent to gain, personal property belonging to another. Yun ang ano niya, yun ang motibo niya kung bakit in-undertake niya yung kanyang pang-hold up. The rape was committed on the occasion thereof or as an accompanying crime. No? Uy, maganda rin yung anak nung papasukin natin si Mang Juan eh. Hindi, tirahin ko na rin kaya. Tirahin na rin natin. The offenders intended to rob personal property. The offenders intent rather to rob personal property preceded the rape. Talagang gusto nila magnakaw. Yung ano nila, second thought lang na nandun na sila, tirahin na rin natin. Rape na rin natin. If the intention of the accused was to rob, but rape was committed even before the taking away of the loot, the crime is robbery with rape. So nakuha na nila, in possession na sila. Pagkatapos bago sila nakaalis, naisip nila na raping yung anak. O, hindi yung lola, yung anak. Then therefore, there will be robbery with rape. If the original plan was to rape, ibang usapan na ito. But the accused, after committing the rape, also committed robbery when the opportunity presented itself. The offense should be viewed as separate and distinct. So, talagang ito, manliligaw nitong babae. Ayaw siyang pansinin. Aray, mamaya, pasukin natin. Ito sa bahay. Or, abangan natin, abduction with rape. No? Kidnapin natin. Sabi ng iba, pagkatapos mo naman pare, kami naman. Sayang naman kami, 3 kami nakaabang dito. 4 sila eh. No? Hindi pwede, akin lang. Kami. Mag-ano na lang kayo, magpa-ripas na lang kayo ng sarili nyo. Or pag i-blow out ko na lang kayo, dun tayo sa isang beer house na may mga ma-date tayo. So, okay, kasundo. So, yun. Yan, nire-rape na niya yung babae, no? Na kursonada niya. In the process, nakita niya may sing-sing. Mamahaling sing-sing yun, no? Na ibinigay nung boyfriend. So, anong ginawa niya? Kinukuha niya, ayaw. O, ang ginawa ngayon, pinuwersa niya, na pinutol yung kamay. Hindi meron tinatawag tayo na violence, no? So, yung pag-rape, ang intention niya. Nung makita niya yung sing-sing, ginamitan pa na ng lakas, pinutol niya yung kamay. So, there is now robbery with violence. Ngayon, anong kaso? Dalawa. Yung rape nauna eh. So, he will be sued for rape. No? Yung iba, siyempre, accomplice sila. No? Oh. Tapos, yung namang robbery niya, siya lang naman nagnakaw nung singsing na yun. Therefore, he will have to face the consequence of robbery. Robbery with violence against women. So, yun ang robbery with rape or rape with robbery. And finally, yung discussion natin na robbery in band. You know, I was saying this in my earlier upload and saying that I have always been a lover of music. In fact, I have always wanted to be a member of the band. At 5 years old, I was already playing the ukulele and the guitar. Very early. Masyadong mawido. And so, as I grew up, and I was joining mga kanta-kantaan, sa kanto-kanto, ganyan, I could not join a band because my parents did not have enough money to buy me an electric guitar. So, puro tingin-tingin na lang ako, naiingit na lang ako sa mga tumutugtog sa banda, patingin-tingin, padikit-dikit, wala. And until I went to college, I never had the chance to join a band. But I've always wanted to play with a band, and because I can play well. I can. Anyway, when I finished my collegiate degree, I started working. And after I've been able to save enough money for my family, maaga ako nag-asawa, napuno na ng konti apartment namin, nag-ipon ako ng pera. Titingin-tingin ako, siguro almost 2 years, punta-punta sa mga music shops until I finally was able to save enough money. Bumili naman ako ng electric guitar sa sarili ko. Kaya itinutusok ko pa rin sa stereo ko na tug-tug-tug-tug. Until I finally was able to get to a company, yung Motorola. Meron kaming major social event. Ang mga bisita si FBR, tsaka yung mga executives namin from Phoenix, Arizona, and also from Chicago. We decided to play a band to refresh them of when they were also young. So we had a band. Malaki pa rin kami siguro. Siguro mga 8 to 12 kami. And I started playing my guitar. First time ko na public performance. So doon ko nakuha yung concept na band. Bata pa ako, alam ko, yung band na tumutugtog, 4. Unang-una, sorry, may drummer, merong lead guitar, merong rhythm guitar, at may bass guitar. So 4 sila. Yung singer normally, singer lang yun. Hindi talaga kinukonsider na band. Technically, kasi yung band, yung may instrumento. Miyembro na rin ng band. Later on, na-advance sa technology, pumasok yung keyboard. So either may keyboard, may rhythm guitar, or later on, nawala na yung rhythm guitar, keyboard na lang. So I was very amused when I discovered in criminal law, yung robbery in band, yung band pala, para rin yung band ng tumutugtog, 4 din. That's the reason why it says, in robbery in band, the robbery is committed by more than 3 armed malefactors. Parang yung band na tumutugtog, dapat meron silang instrumento. More than 3 sila. Na may instrumento. Ganon din naman sa criminal law na robbery in band. So when any of the arms used in the commission of the offense to be unlicensed firearm, the penalty to be imposed upon all the malefactors shall be death. The maximum penalty provided by law without prejudice to the criminal liability for illegal possession of such unlicensed firearm. Ayun. Sabi, when any of the arms used in the commission of the offense, robbery in band, yan, nag-commit din sila, meron silang unlicensed firearm na ginamit. Automatic, robbery yun or robbery with homicide, death kagad, elevated kagad. Sabi nga natin kanina, under the concept of robbery with homicide, magiging special aggravating circumstance yung use of the firearm. Ganon din dito when it is composed of robbers of more than 3. So band na sila. Gumamit pa sila ng firearms. Magiging penalty nila rito is death. Any member of a band who is present at the commission of the robbery by the band shall be punished as principal of any of the assaults committed by the band unless it be shown that he attempted to prevent the same. So, kung ano yung sabog na tugtog, miyembro ka ng banda, damay ka dun sa kapalpakan ng banda or damay ka sa ganda ng banda. Ganon din naman sa criminal case of committing a robbery in band, no? Kung kasama ka sa band na yun, whatever your role is, then you become a principal. Okay? Under the case of People versus Montinola, a 2001 decision of the Supreme Court. Dito siningit lang yung brigandage kasi yung band more than 3. Yung brigandage, no? More than 3 rin na involved kaya baka makalimutan natin in the discussion, we might just as well include it, no? So, in the elements of brigandage, there are 3 or more persons who conspired together. And they want to form a band of robbers. So, ang purpose nila, ba't sama-sama sila, 3 or more, para magnakaw o mag-hold up. The band was formed to steal carabaos. Noon, panahon na yun, nausong brigandage, ang inaabangan nila yun sa highway, yung mga kalabaw. Or siyempre, other personal property, kasama na rin yung kariton, kasama na rin siguro yung mga prutas o mga gulay, tsaka mga bigas na dala-dala. No? Yun ang objective nila. And they would normally position themselves sa highway, all they be going around, to usually doon sa agricultural areas, no, sa mga probinsya, in order to literally extort, no? Babakalan na nila by force. Kaya nga robbery with the use of force, brigandage naman ang nila. The defendants engaged in the organization of the band or joint after it was organized. So yun, ang krimen nila is brigandage. That will now end our discussion on robbery in band. So we're back to our original 4 modules under robbery. And we have taken up for the general principles, and then robbery with homicide, robbery with rape, and robbery in band. Ang very interesting, ito sinagasaan natin na special complex crime of robbery with homicide. Marami tayong magagandang nasagasaan dito. And just to emphasize the point, kanina nauna, yung point nung sa yung possession. No? But there are a lot of combinations. But here, the point to emphasize in robbery with homicide, hindi kailangan yung pinatay yung nanakawan. Kahit sinong namatay, whether yung nanakawan, yung nagnanakaw, bystander, or even may pulis na napatay, that will be the offense for which the accused would be prosecuted would be robbery with homicide. No? So yun, pinasadahan lang natin dito. O tsaka walang accident dyan pag robbery with homicide. Because yan tinatawag natin na DOLO. Okay? At kahit sino pa yung namatay, kahit na yung mga miyembro nila, ang kaso pa rin laban sa kanila is robbery with homicide. Then ito, in-emphasize natin, yung asportation, yung taking away, hindi kailangan yon. Basta na ibigay na sa kanila in possession and control nila, consummated na yung robbery with homicide, no? At kahit na isoli nila o makuha ng owner, tapos na yung robbery nila at consummated na yun. Okay? And so, yun ang mga napasadaan natin, including yung unlicensed firearm. And so, with this, I'd like to therefore close our get-together on robbery. And just to remind you, we have finished in the crimes against property. There are 4 that we intend to cover. We have already finished robbery. Coming up next is theft, no? In another set of uploads, and then stapa, the 3rd set, and then carnapping, the 4th set. So I'd like to thank you very much for continuing your support on our uploads. medyo marami na ako na ikwento sa inyo. If you notice, I am now shortening my little sharing of the little kwentos unless they become really necessary so that you are also able to go through the meat of the topic that we are discussing. So far, mga kaibigan, there were 6 subjects in the bar examination of November 2022. I refrained from uploading my suggested answer to civil law. I think there were already earlier uploads that I give so much respect. Halos tama naman lahat ng mga sagot. I refrain from already uploading my version so that it gives them that kind of courtesy and respect that I give to them for doing a good job in civil law. Maaga 4 days after the bar, naglabas na yung isang batang abogado. Nung tingnan ko naman, tama naman. And however, I waited for more than a month for the upload of the rest of the examination. I started with my supposedly my reputation in commercial law, and I was able to upload that. Immediately, a few days after, yun talagang paborito ko. Ito, criminal law. No, nakita ko mahirap yung criminal law, but I was so excited. Except that my initial answer to one question on rape, I had to recall my answer and update it based on the judgment on the decision issued subsequently by Chief Justice Diosdado Peralta. Pinasok dun yung concept ng initially si Justice Carandang was saying kapag ka above 12, below 18, no, at may consent, walang rape. And later on, minodify naman ni Justice Peralta na over 12, below 18, may consent. Pero, nagbigay ng pera kaya binibigyan ng consent. So, pumapasok ngayon ang concept ng prostitution. Meron pa rin kasalanan yung nag-encourage na magkaroon ng sexual intercourse. So nangyari, ang tawag nun ngayon is sexual assault pagka nagbigay ka ng pera. Of course, the latest one would be from 12, which is the cutoff point, ipinanik na sa 16. So that means, kung may consent man, no, the consent is given, but below 16, statutory rape pa rin. Pero above 16, below 18, at wala namang binigay na pera, talagang full consent. Libre yung partner na lalaki against the concept of statutory rape. Okay. So with this, I'd like to thank you very much. This is my re-upload. And it is almost 12 o'clock. Sana ma-upload ko within the February 8 thing, which is the same date as what I originally uploaded, na madilim yung screen. So, hindi nyo makita yung butas ng aking mga pisngi. So, probably some of you find the excitement in seeing some of the little holes that are there. So, I have to rerun this whole thing. So, maraming pong salamat. I love you so much. I would like to really thank and express my very sincere appreciation. At yun ang tunay na pasasalamat at pagmamahal. Lahat po dun sa mga sumusulat ng comment that they appreciate this series of YouTube slides. Lalo na po yung mga nanggagaling doon sa mga probinsya. Sa North Luzon po, sa Cagayan Valley, Nueva Vizcaya, Isabela, sa Ilocos Norte, doon po sa probinsya ng aking tatay sa Abra, sa La Union, Ilocos Sur, o Central Luzon po, o Southern Tagalog, pati sa Bicol. Dami ho nating mga kaibigan na nagpapasalamat. Doon po sa Mindanao, ang dami, no? Hanggang doon sa Osamis City, Butuan. Kilala niyo po kung sino kayo. O, yung mga kaibigan ko dyan sa Zamboanga, Cagayan de Oro, dito po naman sa Visayas, mayroon sa Cebu, pati puro sa University of San Carlos na magaling na may nanunood pa. Pati po dito sa Leyte, o sa LA, sa Legazpi Albay. O meron po. Tapos sa Bacolod, Iloilo. Marami pong salamat and I am very, very proud of all of you who told me, Dean, mahirap lang po kami, working student kami sa probinsya. Ang hawak-hawak lang ho namin yung aming mga bulok na libro, yung po mga notes namin nung kami nag-aral ng 5 years sa law. At ito lang po ang aming review. Ako'y mangiyak-ngiyak nung bigla nilang isinarado ang kanang greeting, Dean, pumasa po kami sa bar examination. My dear friends, if you only know how much I really valued that kind of news. Talaga pong naiyak po ako. Dahil po, originally, ang balak ko po, yung mga kapwa natin Pilipino na debate ng debate, maintindihan ng batas. Of course, yung aking mga panlaban sa University of Manila College of Law, na maganda naman ang naging performance so far at kaganda pa. Pero hindi ko po akalain yung aking mga pinakamamahal na kapwa ko working student na nakukuha pala sa inspiration, lakas ng loob, at may natututunan din naman. Kaya nga po pag ako may nakabasang, Dean Joe, idol kita, ay nako, lahat po ng hirap at pagod at puyat nauubos po yun sa inyong mga pasasalamat at pagmamahal. Ituloy niyo po yan. Siguro po yan ho ang pampahaba ng buhay natin na hindi doon na malalaos ang ating utak because there are still so many areas in the field of law. Palagay ko po kahit na 20 years na ako mag-share sa inyo, hindi pa po mauubos ang aking sharing dito sa YouTube. Thank you very much. I love you very much. God bless us all. And let us hope that this country will become a better place for all of us. That we will become one day a socio-economic power in the world. Because we are proud Filipinos and we love this country so much. Mabuhay din ho pala yung aking kaibigan. Kung natatandaan niya, mahaba pong kwentuhan namin nung inimbita namin siya sa University of Manila sa graduation speaker para po sa ating presidente, kay President Bongbong Ferdinand Romualdez Marcos Jr. Mabuhay ka at nandito kami. Always know that we are behind you. Murahin na nila kayo ng murahin. Marcos pa rin ang mahal namin. Thank you very much. I will see you soon. Thank you.